Over the years, as a master code professional and a building codes administrator, I've developed PowerPoint presentations for permit technicians. That's what these videos are all about. They will help permit technicians either preparing for the ICC exam or just for professional development. And we encourage you to participate in that. You will have two modules on this. We're going to cover three subjects with the first, three with the remaining. Then we're going to have another training video out there with just a practice quiz. And we'll also have some information on the ICC exams. We encourage you to go to the description and purchase all the code books that you're going to need for your exam and also for your training. We also ask that you please subscribe and like to these videos. The authority to adopt building codes is granted to the states by the federal government in Article 4 and Amendment 14 of the United States Constitution. Political divisions in the state may be granted power to adopt laws regulating construction. Some states reserve the power to adopt building codes while requiring the political division to determine how the regulations will be enforced, whether it will be by political division itself, the state, or a private third party. While some states adopt a mandatory state code, others allow the local jurisdictions to adopt any code they feel will best suit the needs of their community. Those jurisdictions may also amend their adopted codes when they feel that it is necessary. These powers to enact building codes are not given to the states by the federal government, but are reserved to the states in the United States Constitution. The state must establish a legal means and enabling legislation to permit local jurisdictions to adopt and enforce building codes. Each state has a different means by which this is accomplished. One important rule governs all municipal law, and municipal attorneys must constantly refer to it in advising clients as to the extent of the power and authority of any local government. It is Dillon's rule. It states that a municipal corporation has only those powers which are A. expressly granted to it by charter or other state legislation, B. implied or necessarily incident to the express powers, and C. essential and indispensable to the declared object and purpose of the corporation. Almost every power and function of a municipal corporation must be traceable directly or indirectly to some state authorizing legislation and enabling legislation. If no authorizing legislation can be found, then the local government most likely lacks authority to undertake the operation. An express power under Dillon's rule is one that has been set forth and declared exactly. These powers may and do form the basis for direct municipal actions insofar as they are consistent and within the bounds of other higher laws. Examples of those laws are the state and federal constitutions and the state and federal laws of general application. Frequently, state law expressly authorizes or mandates the adoption of a building code by a local government entity. Implied powers either arise from those powers expressly granted or essential to the operation of the powers that are expressly granted. For example, in the context of building codes, the legislation may not specifically authorize the issuance of a certificate of occupancy, but its issuance may easily be viewed as necessarily implied in the powers granted. Ultra vires legislation. If a building code must be enacted in the absence of any express legislation, the opposing lawyer will undoubtedly argue that the legislation is ultra vires, which means that the local governmental entity has acted beyond the scope of its powers. The phrase is customarily applied to private corporations, but it may and often is employed in analyzing the actions of public corporations such as municipalities. The Home Rule municipality is distinguished from other types of local government in that its charter is constitutionally derived from an authorization in the state's constitution. The great dividing line in local government is between the county and municipal forms. A county is usually considered an arm of the state that has been created by the state for governmental purposes. It may be seen as a unit of the state, a part of the state itself. As part of the state, a county is entitled to many privileges of the state, particularly the doctrine of sovereign immunity. A state is immune from suit. Therefore, because the county is considered an arm of the state, a county is also immune from suit. In some states, one very special type of local government is known as home rule. This form of government enjoys greater latitude and discretion in enacting legislation than do other forms of municipalities. While there are certainly very distinct limits to its authority, home rule government may act in areas without specific authorization from the state. Preemption is a doctrine which states that a state may not pass a law which is inconsistent with federal law. If a state enacts such a law, the federal law will take precedence over the state law to the extent that there is a conflict. Preemption allows the federal and state governments to regulate activities which would otherwise be subject to local control. Usually there is a strong state or federal policy being served which cannot be met by the municipal regulations. The most obvious illustration of preemption arises in those states where the state has adopted a building code and prohibits the adoption of a code by the local government. This type of state building code entirely preempts the regulations of building construction. Preemption does not always need to be comprehensive. The state or federal government may select some types of occupancies to regulate, leaving other types to the local government. As an example, in some states, all schools and hospitals are inspected by state officials, and the local building official has no authority whatsoever. Those officials working in these states should be very much aware of which occupancies are subject to the preemption and which are not. An example of preemption is the Consumer Product Safety Act. The Consumer Product Safety Act is an example of federal legislation which can affect the building official. It was enacted by Congress as they felt the state and local governments could not protect consumers from the various dangers presented by many products that were in commerce. An act is just another name for a statutory law and thus has the same power as a statute. This particular act was based on a congressional finding that an unacceptable number of consumer products which were present pose unreasonable risk and injury to commerce. Congress further found that consumers, many of whom were unable to anticipate or safeguard themselves adequately, must be protected against such risk. The Consumer Product Safety Act also sought to help consumers evaluate the comparative safety of consumer products and to develop uniform safety standards. To that end, the Consumer Product Safety Act would work to minimize conflicting state and local regulations. Finally, the Consumer Product Safety Act sought to promote research and investigation into the causes and preventions of product-related deaths, illnesses, and injuries. The creation and enactment of a building code by a local governmental entity is an important legal step requiring caution and advice of an attorney. While the selection or development of a building code is usually the task of building officials, the responsibility for getting it legally operative must rest with the municipal attorney. As it has been previously discussed, there must be some authority for the enactment of the building code at the state level. This is particularly true if the municipality does not have home rule or if the state does not recognize the power as one of the inherent powers of the municipality. The municipal attorney should be requested to ensure there is ample authority for the adoption of such a code by the local government before proceeding. If there is no such authority, it should be garnered from the state before the code is adopted. The provisions of the enabling legislation must be followed precisely. Most states that have an express provision allowing the adoption of building codes, and even those states that do not, have legislation which permits the adoption of various codes by reference. In order to obtain the benefits of adoption by reference, instead of publishing the entire code, great care must be taken to follow exactly the procedural steps established in the state statute. A notice of intent must frequently be published in a newspaper of general circulation in the municipality. This is to inform the public of the pendency of an adoption of the building code. The appendices in the model codes offer optional or supplemental criteria to the provisions in the main chapters of the Code. Appendices provide additional information for administration of the building department, as well as standards not typically administered by all building departments. Appendices have the same force and effect as the other chapters of the model codes, but they must be specifically adopted at the adoption process. Although the fire and building codes can often play against one another, they should actually complement each other. While the building code is designed to mandate the most current building construction techniques, the fire code is designed to maintain the structure against the threat of fire during its existence. The building code is a construction code. The fire code is a maintenance code. Through enforcement of code, building officials serve as law enforcement officers, requiring compliance with code through procedures defined by legal due process. Such a statement does not imply that they are policemen or have the power of arrest, but indicates that they are involved and responsible for the enforcement of certain laws. To perform their duties and function properly, they are endowed with considerable authority. The mechanics of carrying out or invoking either of the components are governed by applicable laws, including the United States Constitution, which provides the building official with a broad spectrum of legal rights, restrictions, mandates, and prohibitions. Omitting or ignoring any required legal step is not permitted. It dilutes the intent and effectiveness of the law and raises serious questions about the integrity or competence of the building code department, who is responsible and may be held accountable. Section 104.8 of the Building Code. The building official, members of the Board of Appeals, or employee charged with the enforcement of this code, while acting for the jurisdiction in good faith and without malice in the discharge of their duties, shall not therefore be rendered liable personally for any act of omission in the discharge of official duties. This does not preclude a lawsuit from being filed and adjudicated. The building official and their agents and the local government may be considered as two separate entities. When a lawsuit is brought, the concept of joint and several liability allows the plaintiff to recover damages from two or more defendants. Code officials who intentionally or recklessly fail to perform a required duty and thereby cause injury may be prosecuted in those states which have criminal law provisions for such actions. Intentional, malicious, and grossly negligent conduct against the code are not defensible under sovereign immunity. 4 standard theories of liability. Number 1, negligence. Failed a duty, no intent was needed. Intentional tort, knowingly violated a duty. Civil rights violation, violated a protected right. Criminal violation, intentional or a reckless act. The 2 primary governmental defense actions include the public duty doctrine and sovereign immunity. According to the court, the public duty doctrine is a focusing tool used to determine whether the state owed a specific duty to a particular individual, the breach of which is actionable, or merely a duty to the nebulous public, the breach of which is not actionable. In its broadest terms, sovereign immunity stipulates that the state may not be held liable for any wrongdoing which it or its agents have committed. This ancient doctrine originated in England, where it was widely accepted that the king could do no wrong. Immunity can further be defined as absolute or qualified. Absolute is a policy of protecting public officials from tort liability. A high-level officer cannot be held liable for the discretionary acts or omissions, and it only applies to actions that are functions of the job. Qualified immunity is more likely to be used for building officials and inspectors. The qualified immunity given to lower administration officers is much more commonly applied by the courts. The rationale behind a qualified privilege is that it is sufficient to protect the honest officer, and the burden and inconvenience of any injury regarding motives far outweighs the possible evils of deliberate misconduct. For example, in Rotkamp v. Young, a zoning official was sued for his failure to issue a building permit for a restaurant. The official found that the description of the activity given to him on the application did not meet the applicable provisions of the zoning ordinance. On this point, the zoning official was overruled via a declaratory judgment, but the court found no tort liability. Respondent superior holds the principal responsible for the wrongful acts of the agent. Therefore, in theory, your supervisor and employer can be held responsible for your failures. However, most states extend sovereign immunity to the government employer and supervisors for negligence performed by acts of the employee caused by either accident or mistake. Liability of the employee, supervisor, and agency depend on jurisdictional laws. A ministerial act is a duty that does not involve the exercise of judgment. A building inspector working under the authority of a building official is an example of a ministerial position. That is, the inspector's work is delegated and performed under the authority, policies, and procedures of the building official. A ministerial act is performed because the law requires it. The act does not involve discretion. The work of the building inspector, as well as the permit tech and other office staff, is considered ministerial acts. When a law, policy, or directive clearly establishes that an act must be performed, the relevant officials are not free to exercise their own judgment in determining whether to perform the act or not. Terms often used are shall, must, and will. A discretionary act is an act of choice. It is a power or right bestowed upon an officer acting officially under certain circumstances, according to the dictates of his or her own judgment and conscience, uncontrolled by judgment or conscience of others. The International Building Code uses words that authorize the building official to carry out discretionary acts. IBC Section 104.10, for example, states that the building official shall have authority to grant modifications in individual cases under certain circumstances. This is an example of a building official being authorized to use his or her own judgment. The most common debate concerning ministerial and discretionary acts centers on inspections. Some are discretionary, while others are ministerial. Two large sources of litigation: failure to inspect where required by law, and performing an inspection in violation of the law. A breach of duty is an element in a negligence cause of action. It is the neglect or failure to fulfill in a just and proper manner the duties of an office. The duty owed by the building official must in some manner have been violated. If the duty is satisfied, no liability will ensue. There are essentially two ways in which a duty can be breached: by action or by inaction. For example, failing to make a required inspection would be considered inaction, which breaches a care of duty. Most building code problems result from inaction. An inaccurate inspection would be considered an active breach of duty. To use more legal terms, a breach of duty can result through misfeasance, nonfeasance, or malfeasance. Misfeasance is the improper performance of some act by a person. Malfeasance is the doing of an act that a person ought not do at all. Nonfeasance is the non-performance of some act by a person who is obligated or has the responsibility to perform. In a negligence case, duty may be defined as an obligation to a particular standard of conduct toward another. Breach of duty can be defined as the neglect or failure to fulfill in a just and proper manner the duties of an office. To prevail on a claim of negligence, a plaintiff must satisfy four elements. The defendant, possibly a building official, must have 1. Owed a duty to another to act according to a certain standard. 2. Failed to act in accord with that standard, and therefore 3. Breached that duty. 4. Thereby causing, in the eyes of the law, an injury or damage to the other. The plaintiff must prove each and every element of a negligence claim by a preponderance of the evidence. For example, If a building inspector has a legal duty to inspect every building in the manner that an ordinary, reasonable, and prudent building inspector would, and he or she has not done so, the first two elements of the legal theory have been satisfied. That inspector had a duty and breached it. On the facts alone, a non-attorney would likely believe that this building inspector was indeed negligent. If the inspector's failure to inspect properly, however, did not cause the party to whom the duty was owed a legally recognized injury, there will be no legal liability. In most cases involving building codes, the question becomes, to whom is the duty to act owed? If the plaintiff is not owed any duty of care by the defendant, the first element of the cause of action is missing, and the case is subject to dismissal. To protect the building official, most states have adopted the public duty doctrine. This doctrine provides that a plaintiff who is alleging inadequate performance of a governmental activity has the burden to show that the municipality owed a duty to the plaintiff, and not just to the general public when performing the activity that gave rise to the complaint. If the activity is designed for the general public, the cause of action fails for lack of legal duty to the plaintiff. Under the public duty doctrine, the courts would look to the purpose of the building code to determine to whom the building inspector owes a specific duty. Therefore, because the purpose of the building code is to ensure the safety and protection of the public at large, a plaintiff's cause of action against the building inspector will probably fail. If a building official approves a building permit for a building with faulty wiring, and the building burns down, all those people whose family members were killed in the fire do not have a claim against the inspector. The courts will find that the duty was owed not only to the inhabitants of the building, but rather to every member of the public. Because the duty was not limited to the people who lived in the building, the duty element of negligence cannot be satisfied. There are, however, two exceptions to this doctrine. The first occurs when a plaintiff can clearly establish that the building official owes a specific duty to a class of people, and the plaintiff is a member of that class. The second exception occurs when the plaintiff can show that there exists a special relationship between the building official and the plaintiff, which would cause the plaintiff to rely on the building official more than he would the general public. These exceptions are almost impossible to satisfy. There are some states that do not adhere to the public duty doctrine. It is very important to consult with the municipal attorney to determine whether or not the state you are living in has the public duty exemption. Because case law is ever changing, this should be checked every few years to make sure that the law has not changed. Let's look at two cases involving the public duty doctrine. In Emringley versus Town of Richmond, the facts of the case were these. The plaintiffs sued the Town of Richmond and the code enforcement officer for failure to properly inspect construction of their house. Problems began to occur with the construction after the issuance of the building permit to modernize their home. It's interesting to note that a certificate of occupancy was prepared but never delivered to the plaintiffs. The courts held that a municipality is not liable for the negligent acts of its employees engaged in a discretionary municipal function. Without evidence of a special relationship between the town and the landowner, no recovery was allowed. In our second case, Fike versus Morgan, the facts of the case were these. Plaintiffs sued the city for negligence for breaching its duty to properly inspect and approve the construction of the foundation of their residence. The city issued a building permit to the contractor owner to build an addition onto the home. The home was inspected over 40 times for compliance with the building code, and a certificate of occupancy was issued. The property was subsequently sold to the plaintiffs. In the hearing, the experts testified that there were numerous violations of the building code. The city argued that the public duty doctrine shielded it from liability because it did not have a special duty to the plaintiffs, just to the public at large. In the court finding, they held that they would decline the public duty doctrine argument. The court found that the city was liable for damages caused by an employee's negligence, and under the circumstances, the employee would be personally liable to a claimant in accordance with the laws of that state. It did find that the legislature could choose to limit the liability for local government in this area by passing necessary statutes. The word tortious is used to denote the fact that conduct, whether by act or omission of act, is of such a character as to subject the actor to liability under the principles of the law of torts. To establish tortious act, plaintiff must prove not only existence of actionable wrong, but also that damages resulted therefrom. Intentional torts, as the name implies, involves conduct that the actor intended to occur. Negligence, on the other hand, involves conduct that was not intended to cause harm, but nonetheless did so, and also breached some duty of care imposed by law. Legal due process is another constitutional right a building official must be careful not to violate. It involves both procedural and substantive due process. The term procedural due process means that parties whose rights are to be affected are entitled to be heard and therefore must be notified. As an example, if a builder has his or her occupancy permit revoked, the builder must be heard prior to the time of the revocation. In some cases, however, the court will waive the procedural due process requirements. For example, if immediate revocation is absolutely crucial to the health and safety of the inhabitants of the building, the court might waive the owner's procedural due process requirement. A building official, however, should never assume that the court will do this. Rather, the building department should, if possible, always give the owner an opportunity to be heard. The term substantive due process means that any and all legislation enacted by government must bear some rational relationship to a legitimate governmental function. In other words, the law must make sense. Courts adjudicate constitutional issues when the parties raise claims of constitutional rights, usually under the 5th and 14th Amendments, as a defense to the actual or threatened enforcement of law against them. If they determine that a law deprives people of their rights under the Constitution, legislators will be on the alert that in the future courts will find this type of law to be unconstitutional. Case study, procedural due process, Massey versus Charlotte County. Facts. The Charlotte County Code Enforcement Board imposed a lien on property owned by the plaintiffs for failing to obtain permits before constructing improvements on their land. The plaintiffs received notice of and participated in the hearing that found them in violation. Subsequently, a building inspection supervisor submitted an affidavit of non-compliance for their failure to comply with the permit requirements after the first hearing. He asked for a fine of $100 per day. The board issued such an order without notice to the plaintiffs. Held. The court found that the plaintiffs were not afforded procedural due process because there was no process established whereby the plaintiffs could contest the imposition of the daily fine. They had received due process during the first hearing, but not at the subsequent order by the board. Until the early 1960s, federal, state, and local governments were almost completely unaffected by civil rights legislation. In 1961 and in the years following, the Supreme Court has begun to interpret hereunto untapped legislation that proved cause of action for people who suffered civil rights violations at the hands of the government. As of yet, lawsuits brought under the Civil Rights Act have not posed too much difficulty for building officials. As is true with state lawsuits and state legal theories, building officials are difficult to reach. Liability against building officials is difficult to establish in a federal lawsuit. Section 1983 is a cause of action under which a state or local government can be held liable for money damages and declaratory relief for violating the Constitution or laws of the United States while acting under the color of state law. Some commentators have declared that no statute is more important in contemporary America than Section 1983. Nevertheless, before 1961, the Civil Rights Act of 1871 was rarely invoked. In the last 35 plus years, however, This statute has become the basis for almost all constitutional rulings arising from the actions of state and local governments and their officers. To review a few definitions in our program, Ministerial Act is working under the authority of a supervisor. A writ of mandamus is a court order where the court commands the municipality to perform one of the duties it is responsible for performing. A summary action is an action such as a stop work order. Actionable means that for which an action will lie, furnishing legal grounds for an action. To continue with definitions, estoppel. Estoppel is a legal principle that prevents someone from arguing something or asserting a right that contradicts what they previously said or agreed to by law. It is meant to prevent people from being unjustly wronged by the inconsistencies of another person's words or actions. Estoppel can be understood by considering examples such as the following. A city entered into a contract with another party. The contract stated that it had been reviewed by the city's council and that the contract was proper. Estoppel applied to stop the city from claiming the contract was invalid. The building permit process is the primary method by which a governmental agency verifies that construction complies with the minimum requirements of the code to protect the health, safety, and welfare of the public. The code is explicit in describing the progressive steps in this permitting process and gives the building official broad authority to carry out the duties. Typically, an application for a permit by the owner or owner's agent starts the process. However, in some cases, meetings or consultations with the building department may precede the application. The steps in the application process and the information gathered in that process are spelled out in the IBC and other I codes. A building permit is actually a license to build. The building official is granting permission for construction to take place on an identified property. Therefore, the permit application is generally lengthy to ensure that all code requirements and legal precautions are observed. Moreover, important information is collected at the permit application stage, which is required by state or county regulatory agencies that license construction professionals or assess property taxes. The issuance of the building permit is the most important step in the enforcement and administration of the building code. Permits are required in Section 105.1 of the Building Code. However, before issuing the permit, an application must be submitted. Handling a permit application is a routine part of the Building Code Department's job. To help them carry out this duty, Chapter 1 of the IBC grants building departments and building officials authority over the process. To best prepare for possible litigation, an application should be extremely specific and comprehensive. Errors in the issuance of a permit may affect the safety and well-being of the inhabitants. Once an application is approved and a permit issued and construction has begun, it becomes difficult to revoke the issued building permit. Courts frequently lean towards not enforcing the code rather than revoking a permit on which a builder has mistakenly relied through no fault of their own. Issuing the building permit is the most important step in the enforcement and administration of the building codes. The application for the building permit and the permit itself are the two most important documents a code official has to determine what the builder or contractor is doing on the job site. It is crucial that the building permit be issued in a prescribed fashion and that all necessary steps be taken to ensure that the permit is issued properly. The permit application and permit itself can serve additional functions, including creating public records that can be reviewed by the local legislative body to determine future needs of the community. In an attempt to avoid liability, the building department can print a disclaimer on the building permit and application to help prevent misunderstandings. Any such action should be reviewed by the local municipal attorney. This disclaimer can state that the applicant warrants the truthfulness of the information in the application and that if any of the information provided is incorrect, the building permit may be revoked. Furthermore, the application and permit can provide that if the permit is issued wrongfully, whether based on misinformation or an improper application of the code, the building permit may be revoked. Although these disclaimers may not prevent the application of the doctrine of equitable estoppel. They may help the court resolve the issue in the building official's favor. Remember that these disclaimers, however, cannot entirely overrule judge-made law regarding the revocation of permits. Another benefit of including a disclaimer is that it may prompt the builder to be more candid with the examiner than he or she might otherwise be. Although disclaimers will not give rise to widespread change, anything that promotes communication between the builder and the building official is a move in the right direction. Additionally, a statement concerning consent to allow for access to the property may also be included in the disclaimer language. Whether the permit issue, revocation, suspension, or denial, all communication should be carefully presented in a written statement from the permitting authority to the applicants to allow for legal due process. If a permit is mistakenly issued and it is obvious that the issuance was a mistake, the building department will be able to revoke the permit without much trouble if, for example, it is obvious that allowing the permit to stand would pose tremendous danger to the safety of the general public. The courts will likely use a common sense approach to determine whether or not a permit should be revoked. So, if the omitted consideration is one which poses a serious safety threat to members of the general public, the harm that will be suffered by the builder as a result of the revocation is far outweighed by the harm that might be suffered by the public at large. Consideration should include: where there is an immediate public safety factor involved, the courts are generally upholding revocation, suspension of issued permits. The doctrine of equitable estoppel may apply. This would preclude a municipality by its action, or lack of action, where there are certain and specific vested rights. See Doles Enterprises versus City of Troy. We'll go into more detail later in this program. The courts held there was a substantial amount of work done, and the permit applicant may proceed. Courts have recently allowed the revocation of the permit, but at the expense of the building official. This is a great consideration. In the Minnesota case of Snyder versus City of Minneapolis, the plaintiff brought suit against the city for damages caused when the city issued him a building permit to build a new building and a permit to demolish the existing building. But the city then revoked the building permit after the existing building was demolished. In his complaint, he alleged negligence, estoppel, and a deprivation of his constitutional rights in violation of Section 1983, and sought an injunction to compel the city to grant him a variance. The court rejected his 1983 claim, but held for him in the estoppel and negligence claims. In doing so, it rejected the city's defense of discretionary immunity from liability for its negligent issuance of the building permit. In spite of this finding of liability, however, the court allowed Minnesota's cap on tort liability to stand, thus limiting the amount of monetary damages the plaintiff could collect. In a similar action, with a different result, in a case in Connecticut, Galacco Brothers Incorporated versus Zoning Board of Appeals of the town of Tewington. However, the court upheld the building department's revocation of a permit, even though the plaintiff had relied on it and begun construction. In this case, the plaintiff applied for and received the zoning and building permits necessary to construct single-family housing on its property. Soon after receiving the permits, the plaintiff began construction. The lot was cleared, excavation begun, and a foundation poured. A few weeks later, the building official realized he had made a mistake in issuing the permit. He ordered the plaintiff to stop work, backfill the foundation, secure the site, and cease and desist from further activity. About a week later, the building department notified the plaintiff that the building permit had been revoked. The plaintiff appealed the building department's revocation, but their appeal was denied. Even though substantial work had been done under the permit, it did not equitably stop the building department from asserting its right to revoke. The court seemed to rely heavily on the plaintiff's knowledge that the issuance of the permit was improper at the time it was obtained, as well as other contributory behavior by the plaintiff. To review Snyder versus City of Minneapolis, the city issued a demolition permit as well as a building permit. the demolition was completed, then the city revoked the building permit. The plaintiff alleged civil rights violation in a Section 1983 suit, as well as negligence and estoppel. The court held for negligence and estoppel and ordered tort liability caps be paid. A traditional rule holds that after the building permit has been issued, work has begun on the project, and if a substantial amount of work has been done, the permit may not be revoked, even if an error was made in its issue. This is assuming that there is no public safety factor involved. The rationale for this can be explained by the doctrine of equitable estoppel. This is a doctrine by which the municipality may be precluded by its actions or by its failure to act from asserting a right which it otherwise would have. Remember to subscribe, like, and support these efforts that we're having for you, and we wish you the very best of luck in your professional development.